911 location of your emergency.
The address, 1122 King Road. One of the roommates has passed out, and she was drunk last night and she's not waking up.
Okay.
Oh, and they saw some man in their house last night. I just tell you what happened pretty much. I don't really know, but pretty much at 4 a.m.
Is she breathing?
No.
Okay.
Why November 13th?
Unknown male B, blood on a handrail. Unknown male D, blood on a glove right outside the residence.
Where is the murder weapon? The clothes you wore that night? What did you bring into the house with you?
Story is exculpatory to Mr. Kohberger. He was not stationary around that house. He was never at that house. He did go to Moscow.
What was the second weapon you used on Kaylee?
A bunch of individuals are saying they didn't know how they were related, and it was just random.
Or it could mean it's not Bryan because his car's got nothing in it, and there were only 13 minutes to do this.
Enough that they were connected via, I think it was Instagram. And
What were Kaylee's last words?
Closing the first week of 2023, Bryan Kohberger was extradited back to the state of Idaho willingly. Surprise, surprise. And according to his Pennsylvania attorney, Jason LaBar, one of the very few things that Bryan Kohberger wanted the world to know was that he was going to be exonerated. They had the wrong guy. On January 12th of 2023, Bryan Kohberger would see his first court date. And he would stand silent by way of his attorney, Ann Taylor. Immediately, things would start happening. Ann Taylor began filing discovery requests. And this was a woman and a defense team, frankly, that didn't miss an opportunity to file a fucking discovery request. After being given some of the discovery through document dumps, boatloads of information, all at once, and some of it completely not pertaining to the defense or the defendant, Ann Taylor starts making bold claims. In February of 2023, Ann Taylor mentions Brady and Gilio, indicating that there's something there. Something is intentionally being withheld that would otherwise exculpate her client. He couldn't have done this. And then in March of 2023, Ann Taylor throws out prosecutorial misconduct. At this point, she's including the prosecutor. She's assuming that whatever they know that they're not telling anyone, Bill Thompson knows too. And it's detrimental to her client because it simply exculpates him. That's her story. Along with the prosecutorial misconduct, we have a statement from one Richard Batanti, a private investigator hired by defense attorney Ann Taylor, in an effort to help with the defense of Bryan Christopher Kohberger. The affidavit of Richard Batanti reads in part, I am a criminal investigator hired by the defense to assist in the representation of Bryan Kohberger. The deaths took place in a 3-story home. Mr. Kohberger is alleged to have entered the house around 4 a.m. while 6 people were sleeping or present, killing 4 people in 2 separate rooms. The people killed were located in 2 bedrooms, one on the 2nd floor and the other on the 3rd floor. Bethany Funk's bedroom was on the first floor. The other surviving roommate's bedroom was on the second floor. Bethany Funk was interviewed by police on several occasions. She disclosed things she heard and things she saw. Bethany Funk was present at the home 8 hours later when police were called, arrived on scene, and discovered the homicides. During the course of my investigation, it became known to me that Bethany Funk has information material to the charges against Mr. Kohberger. Portions of information Miss Funk has is exculpatory to the defendant. Miss Funk's information is unique to her experiences and cannot be provided by another witness. Bethany Funk resides in the state of Nevada, and it is necessary to subpoena this witness because the witness's testimony is material and necessary to this case. Dated March 22nd, 2023. Suddenly, there's an indictment. A grand jury has somehow found that there is probable cause for Bryan Kohberger to see a trial for the murders of MadisonMogen, KayleeGoncalves, EthanChapin, and XanaKernodle. And then Ann Taylor is like, how? How can that be? Not only is there exculpatory information, but there is no connection between my client and any of the victims, or the household, or their friends, or anything like that. And if he committed these murders and then got in his car, why is there no DNA in his car, or his apartment that he went to right after, or his work office that was on campus, where his apartment was, or his parents' house, where you kicked the doors down and zip-tied everyone at gunpoint? Plus, my client has an alibi. He was out, he was driving, he was alone. And that's when the state had had enough. And prosecutor Bill Thompson announced that the state of Idaho would be seeking the death penalty. In August of 2023, two things happened and they made no sense together. August 2nd of 2023, Bryan Kohberger gave a hard refusal relating to waiving his right to a speedy trial. But on August 23rd, he waived his right to a speedy trial. So the trial set for October of 2023 was absolved, to be continued. The year of 2023 brought forth additional information against Bryan Kohberger, however. Initially, law enforcement learned that Bryan Kohberger had purchased a K-bar knife on Amazon. A knife that would suit the sheath that had been found with his DNA on it under murder victim MadisonMogen. They also refined some information pertaining to his phone. And slowly, the number of visits in the area of the crime scene began to grow. They found previous record from DeSales University, where in his studies, Bryan Kohberger had conducted an analysis of a crime scene in which he determined how he would move throughout the crime scene and collect evidence and analyze the evidence that was left behind by the attacker. However, in that crime scene, there were a lot of similarities to what existed in the crime scene at 1122 King Road, including King Road being off Taylor Ave, and the crime scene house at DeSales University being off Taylor Drive. They pulled Bryan Kohberger's DMV and licensing records and found that just 5 days after the murders, the exact day, by happenstance, that they noticed that white car on their neighborhood surveillance, Bryan was in the DMV, changing his plates from a single Pennsylvania plate to double Washington plates, likely to blend in with people that lived in the area, and to get rid of the single-plated vehicle that they were looking for by making it a double-plated vehicle. They'd gone through some of Bryan Kohberger's purchase history records and found that in January of 2022, months and months and months, literally 10, before the murders of MadisonMogen, KayleeGoncalves, EthanChapin, and XanaKernodle, Bryan Kohberger had gone to Dick's Sporting Goods and purchased a black balaclava, a mask similar to that of what Dylan Mortensen would then, on November 13th, say she saw the man in the home wearing. Furthermore, they had gone through and gotten some historical weather records. Because if Bryan was out alone and driving because he liked to stargaze, they were going to prove that on that night, there had been no stargazing. It'd been entirely too cloudy. You wouldn't have seen anything. And at the end of 2023, the crime scene residence was completely demolished. The surrounding foundation, the earth, removed, hauled off in truckloads to an undisclosed location to be buried, with no contest from either side. Is that because they didn't look into some very important things that may have worked for the defense? And did the defense not want them to go back and look into those things? Because maybe those things tied to Bryan, but they're trying to capitalize on them as someone else. Or was there simply fucking someone else also involved? How the fuck is this still a murder mystery? Now is a good time to mention that Bryan Kohberger said he is guilty, so he is guilty, and that is not what we are changing here today. Let's be clear. The year of 2024 started well for Ann Taylor. The year of 2023 went well for Ann Taylor. In the courtroom of Judge John Judge, she was getting little to no pushback at all on anything that she wanted. And for whatever reason that it is, January of 2024, the defense gives their very first hint to the courtroom that they're thinking about a change of venue. They have an issue, and the issue is the amount of publicity that has been involved in this case, the amount of media coverage, the number of interviews that victims' families have done, all the things that are being said about Bryan, including things that are coming from his former friends and the people who never liked him. So, in March of 2024, we have a hiccup. The defense has been doing pretrial publicity surveys, and the prosecution has caught word of it, and they don't like it. They don't like any of it, but there are two questions on the survey that they specifically feel like there's an issue with, and the issue is their lack of truth. So, they bring to court the defense's survey expert in pretrial publicity, Dr. Edelman, where they crucify him about two questions on his survey that everyone in the courtroom agrees are not true. That Mr. Kohberger stalked one of the victims, and that Mr. Kohberger followed one of the victims on social media. In May, more experts will come forth, be it law enforcement officials that did work in the case and defense experts. In April, along with Dr. Edelman, Cy Ray sets forth an affidavit for the defense. He's a CSLI expert, and he intends to come forth and say in court on Bryan Kohberger's behalf that the cell phone evidence, that's not real. It's missing things that are exculpatory to Bryan Kohberger. Other things that may not be, but nonetheless, they're missing. So no one can tell if they are. And when Bryan left his apartment and was out driving alone, he didn't go east toward Moscow. He went west and south. Those are not the same. And this expert was going to say so. But after watching Dr. Edelman be ripped apart on the stand regarding those two questions, did Bryan stalk one of the victims? Did he follow one of the victims on Instagram? No. Did you know that that was not true? Yes, I did, but I was trying not to say it. Well, in April, after hearing that, I reached out to Garrett Discovery Digital Forensic Experts, and the CEO, Andrew Garrett, reached back out to me. See, he had some information. That can't be. His company had dug into Bryan Kohberger's social media, and he did, in fact, follow MadisonMogen and KayleeGoncalves. But furthermore, he was one of the first experts reached out to by the defense, if not the very first. And their consultation regarded Bryan Kohberger's cell phone information. So Andrew Garrett knew that what Cy Ray was saying was true, but Cy Ray was not the right guy to prove it. Andrew Garrett said, the cell phone evidence is in shambles, and it can be torn apart. But there's also a social media connection. Andrew Garrett said, there was a social media connection. Bryan followed Maddie and Kaylee on Instagram. But more so, he didn't stalk those girls. Well, that's because you can't say that, because that cell phone evidence that you have can't prove that, because it can't even put him in the vicinity of the crime scene close enough for you to definitively say that he is the murderer. We need a lot more than that. But what else he also said is, you can't escape the DNA. It is what it is. And that'll always just be true. Those two questions, did Mr. Kohberger stalk one of the victims? And did Mr. Kohberger follow one of the victims on Instagram? Those two questions pivoted the entire case. So after over 6 months of arguing about this change of venue, it finally happened in September of 2024. So let's all meet Judge Stephen Hippler.
Your Honor, we're requesting the court deny the state's motion and allow us to cross-examine their expert, Nicholas Balance, with regard to timing advance
What
records.
evidence do you have that timing advance records existed that the state could have acquired for Mr. Kohberger?
Well, Your Honor, specific.
I've read your affidavit of Mr. Ray, and he seems to entirely ignore the 7-day issue and doesn't address it.
Okay. Are we sure that this doesn't apply in the Kohberger case?
They didn't have needless records.
Okay.
Needless are a very specific type of record right up here.
But you've made some serious accusations against the state of hiding evidence, and yet you've provided no factual basis, zero, that that evidence existed for them to be able to obtain it in December.
Your Honor, his affidavit, I think, starts before to explain to the court some of the history about where the timing advance records come from. When Mr. Kohberger was identified, I'm going to jump ahead and tell you why I think I should get to ask Nick Balance about these records. When Mr. Kohberger came to the attention of the state and they began doing search warrants for Mr. Kohberger's records, on December 23rd, there were 2 separate search warrants for Mr. Kohberger's AT&T records, and they requested timing advance records. And one of the pages that we gave you was the carrier request that said, give us 7 days worth of timing advance records. There were 7 days back, at least 7 days back at that time. Those have never been produced to us. What I've learned in working with Mr. Ray is that obtaining timing advance records now goes through a different process than it went before. FBI agents had a means to get these timing advance records before they were generally available to all of law enforcement. Generally available now comes through the GLDC program, and that happened in 2023.
But he's not indicated he has any evidence that, at least for the time of the murder, that those would still be in existence.
We've never heard from Nick Balance, who is FBI and who has the back door.
From AT&T.
What you haven't heard is the other way that.
That's the other way. I haven't heard that either. I've heard a general description, and I've heard in the affidavit that he received some once and they said, oh no, don't use those. I don't know if those were acquired within the 7 days. He doesn't address the 7 days. And that's a glaring, particularly given the inflammatory language in that accusations in that affidavit, it's a glaring omission. I understand your confusion and concern previously. What I don't understand it is now. In light of the evidence, I don't understand Mr. Ray's accusations without addressing the 7 days that he had that information when he submitted his affidavit.
He is available to testify if the court wishes for him to.
It's his obligation and your obligation to establish that evidence of that the state has this, and you haven't done that. His affidavit is quite extensive, and he seems to ignore that issue.
Your Honor, I believe that that issue is touched on with his knowledge that these kinds of records existed a long time before.
He said that in a very general way about that without reference to the 7 days, and he supposedly received them from some FBI expert to look at for his company, and then was told not to use them. So I don't know, maybe the FBI got them in a way that they weren't supposed to at that time, for all I know. He didn't name names, he didn't identify it, he didn't put it into any context. The state had indicated and provided AT&T's sworn testimony that they only keep them for 7 days. And yet he makes the accusations that he did in his affidavit without addressing that 7-day issue at all. And so I guess my point is if you want to cross-examine the witnesses about why didn't they rely on the AT&T timing information, you've got to show some factual foundation that that was available to them by the time Mr. Kohberger was on their radar as it relates to November 13. It's not an evidentiary issue in which you can lay down Mr. Ray's conspiracy theory without any evidence at trial.
defense cell phone expert is not correct. He's actually incorrect in a lot of areas. And I know this.
Okay. Are we sure that this doesn't apply in the Kohberger case?
They didn't have needless records.
Okay.
Needless are a very specific type of record right up here.
Two. 911 location of your emergency.
The address, 1122 King Road. One of the roommates has passed out, and she was drunk last night and she's not waking up.
Okay.
Oh, and they saw some man in their house last night. I just tell you what happened pretty much. I don't really know, but pretty much at 4 a.m.
Is she breathing?
No.
Okay.
Why November 13th?
Unknown male B, blood on a handrail. Unknown male D, blood on a glove right outside the residence.
Where is the murder weapon? The clothes you wore that night? What did you bring into the house with you?
Story is exculpatory to Mr. Kohberger. He was not stationary around that house. He was never at that house. He did go to Moscow.
What was the second weapon you used on Kaylee?
A bunch of individuals are saying they didn't know how they were related, and it was just random.
Or it could mean it's not Bryan because his car's got nothing in it and there were only 13 minutes to do this.
Enough that they were connected via, I think it was Instagram. And
What were Kaylee's last words?
Thank you, Your Honor.
Or should I permit evidence obtained potentially by searching databases that by its own policies, law enforcement said they wouldn't search?
So a couple points on that. First, even assuming that that's all correct and that they violated the terms,
Seems to be the evidence.
the terms of service, Your Honor, don't affect the Fourth Amendment. The terms of service, and certainly Mr. Kohberger does not have standing to raise a violation of the terms of service. And even if he did, the remedy for the terms of service is not a violation of the Fourth Amendment. As we argued in our brief, the individuals, and as came out in testimony today, the individuals who are utilizing these databases, and we're talking about millions of them, are willingly sharing their information with each other, with millions of other people.
Isn't there a subset that says, but I don't want these people to look at it?
In some of the data,
The FBI, as I understand the evidence, then says, okay, we agree, we won't search those ones.
regardless of what the FBI did or didn't do in terms of violating the terms of service, no one has a reasonable expectation.
Is it different if they share it with the company and it's obtained by lawful process from that company versus going in the back window and taking it?
No, Your Honor, because right now what we're asking is not reasonableness of the search. Right now what we're asking is there even a reasonable expectation of privacy? And so the fact that no one has a reasonable expectation of privacy in those databases means that even if the FBI violated those terms of service, no one has a Fourth Amendment right to complain, and certainly Mr. Kohberger doesn't. He has not asserted factually or through evidence that he was a customer to one of these databases. And maybe that changes the case if he were, but he's not. He's not even claiming that. He's not even asserting it. Now, I do want to address the second part of the court's question. The FBI has indicated that they wouldn't do this. I believe that's a reference to the policy we've been discussing, the interim policy by the DOJ. I certainly do not speak for the Department of Justice. I do not work for the FBI. I'm speaking for the state of Idaho, but I can read a document, and if you look at the policy in footnote 1, it clearly says this interim policy does not impose any legal limitations on otherwise lawful investigative or prosecutorial activities or techniques utilized by the Department of Justice, or limit the prerogatives, choices, or decisions available to or made by the department in its discretion. In other words, their first problem is they're relying on a policy at all. The U.S. Supreme Court has said policies do not equal Fourth Amendment violations. Their second problem is it's a circular argument. The policy doesn't say you cannot do any of these things. It's saying best case scenario, you're not going to do these things.
Well, if you were interpreting this as a matter of contract, wouldn't you have a problem in the sense that on the one hand it says don't do this, and on the other hand you've got a more general sort of catch-all that says, but we're not really meaning anything we say?
No, I don't think there's a problem interpreting that at all. I think the problem is they're much weight on this policy as if it's somehow the law. And it's not. It's indicating, and we heard testimony today about best practices and what those mean. This is indicating best practices, but very clearly stating We are not limiting the Department of Justice to have to follow what's in this document as long as it's not limited by the law. And they're trying to use a violation of this policy or an alleged violation of this policy to say that they violated the law. It's circular reasoning. In Idaho, while this specific issue has not been addressed by the appellate courts have told us what to look for when you're talking about a reasonable expectation of privacy. And it's things like ownership, possession, control, ability to regulate access. Mr. Kohberger had none of those things with respect to the DNA on the knife sheath. We are talking about not just a crime scene, not just a murder scene. We're talking about a murder scene in a house to which he has asserted no connection whatsoever. 4 victims to which he has asserted no connection whatsoever. We're not just talking about his DNA happened to be found in, a dresser drawer or something. It was found on a knife sheath where 4 people were killed by a knife. This is as crime scene as it gets. And that's where the DNA was found. And they can't cite any case law whatsoever. And so they try and just ignore that and skip over it and say, well, let's just talk about the DNA analysis.
Defendant makes kind of hay about the dog barking. And that I guess the magistrate should have been informed that a dog barked for 25 to 30 minutes. And this is just a reach for me. I'm still unclear how this is exculpatory. And again, this fact just does not diminish. Take out all information related to the dog. It doesn't diminish probable cause. Circling back to the cell phones. At the end of the day, this is the proffer is their opinion of the evidence. That's not the basis for a Franks hearing. We're relying on our expert's opinion. They disagree. And that is a dispute that should be had, and it should be had at trial. And I suspect it will. But it doesn't give you the basis to grant a Franks hearing. Defendant then makes some allegations regarding an eyewitness statements related to DM. There's kind of 2 buckets of attacks here. The first bucket is that the defendant claims the magistrate was never informed that DM told law enforcement she, when shown a picture, didn't recognize the defendant. I think that it goes to getting a general description of the person that she saw in the residence around the time that corroborates when we know these crimes occurred. Yes, a general description is material and relevant. And that general description, which is what was provided in the PC affidavit, was consistent throughout all of her interviews. She described seeing someone wearing all black, a mask with only a portion of their face showing invisible. This person was male, white. She heard a voice that was not someone that she recognized. The person was a slim, skinny, lean build. And the person was taller than she is around 5'8". That's what's important. It was that general description. And that general description did not change. That the timeline matched the vehicle surveillance of when a suspect vehicle is coming into the area of 1122 and then leaves, as well as text communications of her relaying what she's observing during the same time period. The second issue, the second kind of bucket that they take issue with DM, is about these other just statements that she gives during her interviews. The defendant argues when an eyewitness states she's not sure anything she saw was real, a magistrate should know about it. Well, the simple answer is investigators knew what she saw was real, and we know it wasn't a dream because they found the evidence discovered the next morning. Those statements didn't need to be included in the PC affidavit because they weren't exculpatory. They didn't support this idea that this didn't really happen, that somehow we got it wrong. Next, defendant attacks the vehicle identification. Well, this picture they're painting about how this happened just is simply not true. The magistrate was given a very detailed picture of the investigation at the related to the sedan, which was later determined to be a Hyundai Elantra. This was about 5 pages of the probable cause affidavit. The reality is, still images and video were provided to a vehicle specialist. Based on his review, he provided information to investigators that the suspect vehicle was likely a Hyundai Elantra. There was some discussion regarding what was the most appropriate year range, but at the specialist's direction, the year range to be focused on was 2011 to 2016. So Detective Payne reasonably relied on his expertise as a vehicle specialist and included that in his probable cause affidavit. And the court has in front of it the emails attached as exhibits that show that's exactly what occurred. And the defendant appears to argue that, well, the vehicle specialist shouldn't have relied on this video because they can't tell that that was a Hyundai Elantra. To them, it doesn't look like, I guess, a Hyundai Elantra. And the video that is clear, well, they take issue with that video because, and specifically we're talking about 1125 Ridge Road, because they say, well, that can't be surveillance video of the white Elantra, even though it was caught on video about 0.3 miles from the crime scene, about 3 minutes right before when we see this suspect vehicle enter the area of the crime scene, which 0.3 and 3 minutes appear to be the amount of time it would take the vehicle to travel to the area of the crime scene. They say, well, that can't be the right video, because if it were, then the surveillance right up the street would have also caught this video. But we know that's not true. And that's been submitted to this court. Excuse me?
When was it submitted to this court?
Well, it was submitted through my response.
I was afraid that you were going to say.
It was submitted through my response that their logic is flawed. And I can tell you, it has since been confirmed. I do not have, and it has been discovered to defense. We had Special Agent Hill confirm, and he discovered this as Bates 15990, which confirms that the surveillance camera that was set up to capture motion would not have captured the corner the defendant says must have been necessarily captured. Again, it doesn't matter. At the end of the day, the defendant's speculation about the route of travel and their differing opinion on it isn't the basis for a Franks hearing. Defendant the next area is the footprint. There was a footprint found outside of DM's bedroom. They claim that the inclusion of this was misleading. But again, there's nothing misleading about the statement. The statement says during the process of the crime scene, the investigators found a latent shoe print. It was located during the second processing. It came back using a presumptive blood test and showed the presence of cellular material. They let the judge know that it was outside the door to DM's bedroom located on the second floor, and it's consistent with her statements. Yeah. The investigators provided the magistrate the information they had at the time of the investigation. Defendant's opinions about where the shoe print should have been located and it couldn't necessarily have been located there, again, that just doesn't rise to the level to warrant a Franks hearing. Again, our case doesn't hinge on the identification of the shoe print. Neither did the PC affidavit. There was sufficient probable cause with or without this information. The information that he was given from...
This goes to my first question about imputed erroneous statements. So I understand the allegation in that regard, not necessarily to be that Detective Payne knew the statement was wrong, because I'm not sure there's evidence of that. But did the CAS specialist know that there was a misinterpretation or an erroneous report?
I don't think that you have before you a sufficient proffer that proves that the CAS specialist submitted false information. Apparently, there's a difference in the handoffs of 7 minutes. At the end of the day, okay. No, I don't think it's incredibly material.
Is it material if you look at it in terms of where the phone was in that 7 minutes?
Well, it's material.
Going a direction different than what your affidavit says it was going, isn't that material?
The direction of travel, like, yes, I would say it was if it was found outside of Pullman. It was not. It was reporting to a tower in Pullman. This assumption assumes that cars can't change direction of travel.
Your Honor, we're here because the state has alleged that a single piece of evidence ties Mr. Kohberger to this case. They've alleged that there's a knife sheath that has DNA that they allege matches Bryan Kohberger. He's now been incarcerated for 2 years, facing capital murder. The real story is exculpatory to Mr. Kohberger. He was not stationary around that house. He was never at that house. He did go to Moscow. He did drive around, but he wasn't over there. And the phone records absolutely show that. There's a reason why there's so much secrecy. That's because there's a violation of privacy rights. That's why there's so much secrecy. Your Honor, this is an extremely important motion, and the court is going to decide whether we do have any expectation of privacy left or not. The IGG evidence in this case should absolutely be suppressed. The court can see from the various affidavits in this case that there's a lot of things done that don't say how Mr. Kohberger was identified. And the reason for that is because nobody wanted to talk about what happened here with the genetic genealogy. That search was done by making a profile in Othram Lab. That search did not lead anywhere. We learned about investigative work that was done after Othram had done the work that they could do and before the FBI took over, that we learned about for the first time this week. Not through the motion to compel process. This was a giant secret. We know that by the time the FBI gets involved, the profile, the text file, that's a snip to use to try to identify somebody is more than twice as big when it gets to the FBI from Othram. We don't know.
Can you tell us why we're back inside?
When we get to the FBI, we don't know who did the work. You heard that any of that information is redacted. We don't know who did the work. It's a giant secret. The FBI took over the search, and from there they did things that we have no idea what it is. That part of this case is secret. We don't have any notes. We don't know who did any of the work. We don't have any lab protocols. We don't have any quality assurances. It's not reliable. You heard a lot of justice interim policy, and that policy it's on page 6 of that particular exhibit that the court has. It says that they're not to go into databases that aren't allowed. And they did that. The court has that in another exhibit. Finally, there was a trash pool in Pennsylvania, and there was no warrant for that trash pool either. All 3 of those stages of this case, there should have been a warrant, and there wasn't, and this must be suppressed. Your Honor, for the purposes of the Fourth Amendment protections and Article 1, Section 17 of the Idaho Constitution, we are looking to see if somebody has a privacy interest that society is ready to support.
A constitutional violation?
Your Honor, it goes to privacy.
Suppressed for contractual violations or even statutory violations?
Your Honor, I'm not sure what the court is asking me.
Well, it goes to whether or not your client has standing to complain about the searches of the databases because as the state has posited, that wasn't his DNA that was searched. At best, it was his ancestors.
Your Honor, in this case, there were a lot of search warrants. I'm going to draw the court's attention to those beginning on December 23rd. That day is important because it was just a few days prior to that for the first time ever, Bryan Kohberger's name came up in the course of this investigation. Your Honor wouldn't know that by reading the affidavits for probable cause. Nobody would know that. That's because that information is omitted from the affidavit. That information is something that you heard about this morning in testimony, that but for the FBI's work going into databases they shouldn't have been going into, violating their own policy, keeping no records, and doing this all behind the scenes in secret. That's the only way a name was produced. Prior to that time, the lead detective in the case had not heard the name Bryan Kohberger. He had not crossed their radar.
Is there anything
that's nowhere in the affidavit, and that's important because that's intentionally withheld from the affidavit because of the work the FBI did. Because the FBI went behind the scenes and did things that they shouldn't have been doing, because they searched databases that they shouldn't have been doing. We don't know what else they did wrong because everything else is a secret. We don't know what else they did wrong because there's no record kept. There's no process kept. We can't rebuild the process that they did to identify Mr. Kohberger. We can't do any of that because they kept no records, produced no records, and did this all behind closed doors, and it was withheld from the magistrate. Your Honor, the purpose we're here for today is to offer you a preliminary showing of why we should have a Franks hearing. To do that, we will show you that in this circumstance, the affidavits that supported search warrants in this case had false information in them that was intentionally placed there. There was intentional omissions of information that are material and exculpatory to Mr. Kohberger, and without the false statements and with the added information in, probable cause on the warrants should not be found. Today, I'm asking you to listen to what we have to say, look at the exhibits that have been admitted, and I'll walk through those with you to talk about the 13 areas. And at the end of this hearing, we will have met the preliminary showing required in order to schedule a Franks hearing and fully challenge this. So it's based on this false investigation trail, and it's based on statements that are completely out of context from somebody that they interviewed that are incorrect statements when you take the totality of the circumstances together, and statements that this person disclaimed a couple of days later because she wasn't sure what she remembered was real, and give that to the judge. If you add in the missing piece of IGG and what happened with that, and as a judge, you know you've got law enforcement willing to violate their own policy, and you know that you're not being told the full story about what a witness is saying, and you're being led down this path to say there's a real investigation when there wasn't a real investigation, you don't find probable cause on that. I want to go through these. I won't read them in their entirety to the court, but Your Honor asked the prosecutor what they were. And I counted up, and at the very first interview, remember the issue was whether or not one of the victims ran downstairs, and she didn't say it once. She said it 4 times in a row in the very first interview, and that just didn't happen. It just couldn't have happened, and that was not told. In fact, that statement was brushed over and withheld from the magistrate. About the memory issues in the second interview the same day, there are 2 references to not remembering. A couple of days later, there's the third interview, and there's references to not remembering, being drunk, a statement, I don't know any of it, like half the stuff. I don't know if it's a dream or if it's real. That's at page 399. At page 406, I don't know if this was real or in my mind was just like playing with me. But from what I think I heard, someone was crying in the bathroom. These are definite statements that were not given to the magistrate and in fact were brushed over. And credibility is really, really important when that person is relied on in the investigation. The credibility of the witness that they talked to, the one that they cited information from, that was relied on. That appears in these affidavits, and it's relied on after Mr. Kohberger's identified to say, well, he has bushy eyebrows, so this person has to be right. It's relied on when the police officers put into the affidavit the footprint that I didn't talk about on my first one. We gave the court the photographs of it. I'm happy to give the court these. That's a misleading statement to the court or to the magistrate that was asked for probable cause. This footprint is at the very edge of the door. It's a single footprint, and it's not repeated throughout the house. So to act like that bolsters this witness, important, especially in context of the misstatements of the witness. This probable cause affidavit talks about an interview they had where the person that was interviewed said that she heard things and saw things within her house. But what is written in the probable cause affidavit is seriously lacking in detail. It's wrong and it's false in many places. The way the affidavit reads, it says, this person stated she went to sleep on the second floor. She was awoken at 4 by what she stated sounded like one of the victims playing with the dog, which was on the 3rd floor. A short time later, she thought she heard one of the victims say something. That caveat, she thought she heard, is a problem. That's not at all what was said. This person was interviewed shortly after 911 was called in the afternoon of November 13th, 2022. And she was sure, I'm at Defendant's Exhibit 8A, page 281, lines 4 through 10, when this witness was sure that she heard this particular victim go down the stairs, go up the stairs, and then come running back down the stairs. That is not what's contained in this affidavit at all. That is repeated during this same interview a couple of different times at page 287. It's also repeated in a subsequent interview that same day. This is Defendant's Exhibit 8B. That's at page 313 and again at 320. And I've got one more of these where this is repeated. It's repeated again in D8C as well. That is important because that's misleading to the judge. That waters down what was said, and that matters in the probable cause affidavit, because the officers, when they wrote this, knew that wasn't the case. They knew this particular person that DM said was upright and running down the stairs, but that's not what happened. That person was killed in the bed and never left the bed. And so the officers water that down because they know that fact is wrong, but they don't tell the magistrate that. They also don't tell the magistrate that this witness has claimed memory problems, that this witness has claimed that she's not sure what she heard or saw was real, or whether it was at a dream, and that is contained in defendant's 8C, and that's going to be beginning at page 396, 398, 399, 403. There's further statements from that witness in that police interview that said that she had had too much to drink and couldn't remember. None of that is given to the magistrate. That is information that's withheld. That's credibility of the person telling law enforcement these things, and the magistrate had a right to know that whatever is laid out in here isn't exactly the way it was. That person had credibility issues, and she said things that were just absolutely untrue and couldn't have been true. Law enforcement knew that. That was intentionally withheld from the magistrate. That matters when we're talking about credibility and sets this whole thing into motion. Law enforcement in their affidavits talked about this dog barking, and they key some time, and they say this is when something was happening inside this house. We can hear this dog barking, and they use the videotape to get a time off that surveillance tape from the neighborhood, the 1112 King. And so they've got this time, but they also have this video, this trail that they've picked out a time that something probably happened here, and they don't tell the magistrate that this dog that's barking continues on long after the car they're interested in has left the area and then abruptly stops. Your Honor, the dog was found the next day inside the house in a bedroom with an open door, where the other bedrooms that contained people that died, their bedroom doors were open, and this dog had not tracked any blood around. The dog had no blood on it whatsoever, but it was just sitting in an open room a day later. The magistrate is not informed about that either. If the magistrate had the other facts, I think the magistrate would have some serious concerns and would not find probable cause. Your Honor, the vehicle, and I know the court knows what I'm going to say, there's not DNA in that vehicle that was brought out from a crime scene. This absolutely matters, Your Honor. If you want to go to the state's theory, right, with their videos that they've talked about, they told the magistrate about, that this is the video, this is what matters, it parks at this certain time, it leaves at this certain time. If you want to go to that, there's about 13 minutes of time. Right? 13 minutes between the last time you see the car and the next time you see the car on the video. And if you end up with a car that's searched, and I mean searched and taken apart, the brake is taken apart, the gear shift is taken apart, the key fob is checked, there's no blood on any of that, none. The steering wheel, there's some kind of spray all over the interior of the car to check for it. There's no blood. I think that there's context that the magistrate should have known that's absolutely exculpatory to Mr. Kohberger, and it matters a whole lot. There's also the identification to the sheet that maybe seems like it would be really good. You don't really even know how that happened, and you don't know how it got there. This isn't like DNA in blood on the wall from Mr. Kohberger. That's not there. That doesn't exist in this scene. You're talking about an item that the question of how should be, especially when you know about the other male DNA in the house, and especially when you know about the lack of DNA connections. If the magistrate judge had been told there's unknown male B in blood in the house attached to the handrail, that might have made more of a difference to her. Maybe a sheath that can be carried to the house and blood in the house that's not the same, maybe that matters. And then maybe the car being completely empty of any blood DNA connection, maybe that matters a little bit more. I think the most prominent question is, how did that sheath get there? And I think when you ask that question, I think you can have DNA on an object at a scene when you know about all of these other things and you don't find probable cause, because there are more questions than there are answers. And all of a sudden, this one thing doesn't look as big. It doesn't look as everything pointing to it when you have the context around it. The magistrate didn't have to have every detail of the case, but knowing how many attempts to find a DNA connection there were, and it didn't exist in Bryan's car, in Bryan's apartment, that there's no other DNA in there other than unknown male B that we know of for sure, and unknown male D outside. There is a lot of context there, and all of a sudden this one thing, the question of how is that there, is the question that the magistrate should have had. And then we come to all of the other things that we've talked about. I don't think probable cause is in a vacuum. I think probable cause isn't one thing. I hope it's not one thing. I hope there has to be a little bit more than one thing, especially when you've got another thing that's the same as the one thing.
Well, I said I wouldn't do this, but I'm going to do it anyway, because you brought up blood DNA of an unknown individual that was found, I think, on that handrail.
Yes.
Doesn't that necessarily not exclude Mr. Kohberger? What it may do is suggest there might be a potential other person in addition involved, if you assume that that blood was related to the victims and not some earlier event in the house.
If what the court is saying is exactly why the magistrate needed to know that. Is there another explanation here? I've got this sheath, but there are all these other things that if I know about them matter. What's the other explanation? What's going on with this investigation? What's happening here? That's exactly the point, Your Honor. What other explanation is there? The magistrate wasn't given a chance to ask that. She wasn't given a chance to ask that when she wasn't told about unknown male B, blood on the handrail. She wasn't given a chance to ask about that when she wasn't told about unknown male D, blood on a glove right outside the residence. She wasn't given a chance to ask any of those questions. She didn't know that Bryan's car, and the court's question, good question, what does that mean? Could it mean there's one person? The answer to that is, or it could mean it's not Bryan because his car's got nothing in it and there were only 13 minutes to do this. The real story is exculpatory to Mr. Kohberger. He was not stationary around that house. He was never at that house. He did go to Moscow. He did drive around, but he wasn't over there. And the phone records absolutely show that. Probably the worst part of that is relying on, after the BOLO went out for 2011 to 13 Elantra, then WSU, Washington State University officers find cars. They find one that's registered to Bryan Kohberger, parked at the apartments he lived in, but it was a 2015 Elantra, and so they don't really do much with it. But this is placed, that is placed in the affidavit like it was an investigative fact, and it wasn't. It was on the 20th of December when the detective, the lead detective, got a hold of WSU police and found out about that and said, oh, hey, you called this in. He didn't know about that before, but there's no context around that. That's just stacked in there like it creates probable cause when it doesn't. Once the second AT&T warrant comes, then you end up with warrants for Mr. Kohberger's arrest. You end up with warrants for DNA samples to be taken, warrants for the search of his apartment, the search of his car, the search of his parents' house. Those are the warrants that are next implied in that. Here, what's added to that set of affidavits is the paragraph that talks about Mr. Kohberger's phone using a tower that provides service to 1122 King on a number of occasions. The PC affidavit says 12. Your Honor needs to take a look at, it is D1B and C. That's an email from Nicholas Balance, and he's talking to the detective in Moscow about the dates that he says this thing happens. And then he puts those dates in his cast draft report and in his cast final report, and they don't match up. There are different dates on those, different times on those. But the really big deal about that is that it's misleading when you say the cell tower that also services this particular location. Moscow has, I think, 2 cell towers that service the town. Those cover places that one shops, places that one eats, places that one gets gas in Moscow. From the records, you can see handoffs, and so you know where a vehicle is going. You can know whether it's stationary or not. You can know whether it's parked, looking at a particular place or not. Based on those records, we also provided the records just so the court would know there's a volume of records. I don't expect the court to decipher those records, but based on those records, they absolutely knew that Mr. Kohberger wasn't around that residence, wasn't parked near the residence, didn't stop and have his phone in a stationary position at that residence. They absolutely knew that that's not what was happening, but they put it in there to make a connection that didn't exist. They put it in there so that the judge would think that this was the right person, and they shouldn't have done that. They knew that was incorrect. They also changed that quite a bit, performed a drive testing, and so there were other bits of data that kept coming in so that they would know that was untrue. Now, for a magistrate to be relying, remember, on somebody who's a witness, somebody who's been interviewed 4 or 5 times, and continually says something that's absolutely impossible, has memory problems, and the judge never knows that, and we'll keep the IgG identification off to the side, but then you have this false narrative that looks like stalking, that looks like following, and it's not true. That is extremely damaging. It's very misleading. It's an outright lie to the magistrate. When you omit that kind of information, when you take that context out, you might as well say stalking, because that's what you're trying to say, and you know that's not true. No connection between the people in the house and Mr. Kohberger based on their cell phones, based on social media accounts. There's just no connection. We'll move forward to the set of warrants that come a little bit later in February, March, April. I'm talking about Amazon, Google, Apple, those kinds of warrants that come later. Here's what is left out of all of those warrants. The fact that Mr. Kohberger gets arrested, his apartment gets searched, his car gets searched, his car gets searched again, and his car gets searched again, and there's absolutely no connection between him and anybody from 1122 King. I mean, that's the ultimate question that will be before a jury. What does that mean, right? What does a knife sheath at a scene mean? That's going to be the ultimate question. You're
Killed by a knife, that probably means a lot.
It might mean a lot.
Probable cause is not a proof beyond a reasonable doubt standard. It's probable cause to think that this person might have done it. And I'm not sure how that direct DNA connection to a sheath found on or near one of the victims doesn't close the book on anything on probable cause after that. Even if disclosed. Preclude a finding of probable cause when there's a DNA match between the DNA and the sheath and Mr. Kohberger. Isn't that probable cause every day and twice on Sunday?
The magistrate didn't get to know that.
In fact, his DNA is still on the knife sheath, though. That's the problem, counsel, for probable cause purposes.
If that's the only thing she's told, I can see why she'd find probable cause. It's these other things that are withheld that create a context around it. I think the purpose of Frank's is to ask this very question, and this is a question. What do we want to do with our criminal justice system? Do we want to have one thing with no context around it when there's this other context that really matters?
The Frank standard, which is, even if you add that stuff, does that take away probable cause, counsel? And my problem is, once you have a direct DNA tie to the defendant, for purposes of probable cause, this isn't for purposes of conviction, for purposes of probable cause, you have not explained to me why a reasonable magistrate, let alone any magistrate, wouldn't find probable cause there, even if they knew all those other facts. As to Mr. Kohberger, now, there may be, as you say, other people that creates concern or issues about that need to be investigated further, but I'm not sure that that diminishes the probable causes to Mr. Kohberger if his DNA is found on a knife sheath found on or near the victim who was stabbed with said alleged knife that would have been in said alleged sheath. There are other things in the affidavit that, or affidavits at that point, that could explain that, including the wearing clothing and covering gloves and all that could be put into a bag real quick on the way out that was in one of the affidavits.
But Ann Taylor and Bryan Kohberger would capitalize on the things that law enforcement either missed or were aware of and didn't look into. The things that law enforcement officials could never really affiliate with Bryan Kohberger. And there were so many. In fact, there were more things that couldn't be tied to Bryan Kohberger than there were things that could be tied to Bryan Kohberger by law enforcement officials' own admissions. And the prosecutor backed them up. So we will discuss the things that didn't tie to Bryan Kohberger. All of these things work nicely for a defense. For example, the man at the Winco. That wasn't Bryan Kohberger. Everything that may have been evidence, but it didn't pertain to my client, so you didn't explore it. So the person who got online and sparked this rumor that there had been this fight at Sigma Chi that Ethan and Xana were involved in, that wasn't real, and that wasn't Bryan either. None of the Daves were Bryan. The person who mentioned the sheath and debunked the white car and called it a red herring, Papa Roger, wasn't Bryan. What the fuck? One of the best ones to not be Bryan, the fucking man in the woods. So let me get this straight. The number of times that he visited the area within 300 meters of the crime scene increases over the course of this situation. But he's not the fucking man in the woods. That's going too far. I don't know what else there is to say. She had a great story. That's why they wouldn't let her tell it. Either because they didn't do the work to prove that those things were Bryan, or because those things were not Bryan Kohberger. Dylan Mortensen saw the attacker carrying something, and the police never told you what that was. And the reason why is because it doesn't suit a K-bar knife. That's not angled. That doesn't have an arrow shape. There's no points on it. It's not cylindrical, but has like ends. You heard what Dylan Mortensen said. A K-bar knife doesn't suit that. The sharpener doesn't suit that. The sheath doesn't suit that. None of it suits that. Arrow shaped. Bethany heard a firecracker and a sparkler of some sort went off. She saw it. Is that why the perpetrator left so quickly? Because after they pistol whipped Kaylee and Xana, causing blunt force trauma, at least once, one time, the gun went off by accident. Is that a thud that you hear at 4:17 a.m.? Or is that the firework that Bethany heard? How do you know? There's DNA on the handrail. There's DNA under MadisonMogen's nails. There's DNA on the gloves outside. The front door was open in the morning by a witness account. The perpetrator that Dylan saw went out the back door. The shoe print, by Ashley Jennings' own admission. They were never able to identify the source of the shoe print. It's not Bryan's. There's no connection to these victims on social media. Bryan is not Papa Roger. Imagine that. Bryan is not the person who posted the 4chan riddle. But the person who posted the 4chan riddle knew where Bryan Kohberger lived. Imagine that. Imagine that. What we are trying to decide is, do the missing pieces actually fill in the unanswered questions? Or is there simply an entire other entity that may have been involved in this and gotten away? Now, I'd like to think the former, but by the end of this, I assure you, we'll all be equally confused. Because again, law enforcement said many of these things were not able to be proven as Bryan Kohberger. And they wouldn't go as far as to say that they even thought these things were Bryan Kohberger.